Hello, good morning, everyone. Thank you for joining us today to discuss what is the hottest topic in town, which is Rachel Reeves's historic budget. My name is Daniel Church. I'm a partner in the private client team in our Watford office, and I'll be chairing today's session. You'll see that I'm joined today by several colleagues from the VWV private client team, Rachel Armstrong from our Birmingham office, Leila Gadadzi from our head office in Bristol, and Angharad Lynn, Judith Cuxon, and Amish Patel from our London team. And we're also joined today by Alex Waino-Park, who's a partner in our tax team, also based in London. It's great to see so many of you here today. I think there were nearly 200 of you registering to attend, which is fantastic, but also does go to show just how important last week's announcement was for so many of you. We are, where are we? We're 6 days on now from the budget last Wednesday. Usually we'd be starting to see the dust settle on some of the various changes that have been brought in. But given that so many of the changes, as we'll find out today, are so far-reaching and also yet to be consulted on, it could be many months, to be honest, before we are really in a position to see how the tax landscape is going to change. So with this, I have to issue the usual warning regarding anything we cover today. The session is recorded, but nothing we cover should be relied upon until you've obtained specific advice relating to your circumstances, because it can vary so much from person to person. With that in mind, again, after today's session, please don't hesitate to get in touch with us to obtain advice on anything we've discussed or anything else that you're concerned about. And we'll post a slide at the end of today's session with contact details for everyone so that you can contact the person who is based in the office closest to you. Today's session, as you'll see, is designed to be a panel session. I'll be putting questions to the various panel members to get their take on the various private client specific issues that came out of the budget. If you have any questions, please do use the Q&A box on your screen. We'll try to get through as many of those questions as possible at the end of the panel discussion, or if there's a particularly good question that we see that is relevant to what's being discussed, we can bring it up at any time, but we'll aim to do the questions at the end if we have time. If we can't get to any of your questions because we've got too many, then we'll endeavour to come back to you directly after today. We will be sending out follow-up emails to you following today's session with a recording of today's session so that you can look at it over it again if you need to, but we'll also get back to any specific questions that any of you have. So that's the introduction done. First of all, we're going to go over to Rachel Armstrong, and Rachel's going to provide a reminder of some of the changes announced which will affect private clients. So over to you, Rachel.
Thanks, Dan. Good morning, everyone, and welcome. It's brilliant to be in front of you all, to be able to present to you by way of a panel discussion, allowing all of the brilliant people who I work with being able to answer some of the questions and some of the changes that have been introduced last week in the current Labour government's first highly anticipated budget. Prior to the budget, there was a lot of speculation as to what the changes would be that are going to be introduced. A lot of our clients opted for a better the devil you know than the devil you don't approach, and we have been extremely busy over the last month or so with people wanting to transfer monies to other people, transfer assets that are heavily laden with capital gains tax, set up trusts. Some of it probably a bit premature now whenever you look at it. Some of it really, really good planning, actually, when you look at it now in hindsight. The budget didn't fail to surprise us, as you are all aware, especially with the changes to agricultural property relief and business property relief, and of course bringing pensions into the estates for the calculation of inheritance tax. Although we are going to discuss some of the changes today, we must point out that there is going to be a consultation period in early 2025. So a lot of the bolts and nuts that are going to form part of that will be discussed in the consultation period. So there's probably going to be more talks like this whenever they've all been ironed out. The main changes, as you can see from the screen in front of you, are changes that we're going to be discussing today, are the changes to the inheritance tax, the capital gains tax, and the domicile regime being scrapped. So if we move on to the changes to the inheritance tax, first of all, the main things are that from April 26, the capping of agricultural property relief and business property relief to a minimum to a maximum of £1 million per person. And with this comes a lot of conditions as well. As a farmer's daughter myself, and seeing what actually land is worth and the assets and how this is going to affect farmers, I do ask that, you know, if you do see any lobbying or anything like that, please do join in on any of this to try and get questions answered from the government as to how this is going to work. On calculation, myself, when I was looking at this and dealing with farming clients, basically any farm that's over 80 acres at the minute is going to fall into this. They did say there wasn't going to be very many farms affected by this, and there would be about I think they said about a quarter of additional farms would come into this. But actually, if you look at the NFU website, they're saying probably going to be at least 50% more farms are going to fall into this regime now. They've also frozen the residential nil rate band and the nil rate band at the current rates until 2030. So they've increased that for another 2 years, which is effectively a reduction in the relief available when you take into consideration the inflation rates. And then also you'll see on there that from April 27, the pensions are going to be taxed as part of the estate on death, which is going to include then defined benefit schemes, foreign pensions as well, your normal self-invested pension plans. And it's estimated that this will bring an additional 10,000 estates liable to inheritance tax for the 27-28 tax year. And then an estimated 40,000 estates will be liable to more inheritance tax as a result of the pensions coming into the estate for inheritance tax. And then moving on to capital gains tax on our next screen. The new rate took effect immediately. So any of those people that had large gains and wanted to get them through and sold, they've done the right thing. They basically have raised the capital gains tax rate so that they're in line with the current, or what was the current residential capital gains tax rate. So they've risen now to 18% and 24%. The current rates of the current reliefs have not changed. So they're going to stay the same, which are currently £3,000 per person per year for the remainder of this tax year. So there's more tax on capital gains tax, no real light at the end of the tunnel, shall we say. And then moving on to the final one that we will be discussing today, which is the non-dom rules. So the non-dom regime will be abolished from the 6th of April 2025 with a new residence-based system in place instead. So without further ado, I would like to pass you over to my colleagues, who Dan has alluded to, but just to give you a bit more detail. As part of the panel, we've got Judith and Amish, who deal with a lot of our trust work. We have Angharad, who deals with a lot of our international work and planning work. Dan will be chairing the panel. Dan deals with a lot of our succession planning and the estate planning work. We also are joined today by Leila, who deals with a lot of our charities legacies protection for the charities team, and also estate planning and succession planning. And we're very happy to be joined by Alex Inopark, who heads up our tax team. Alex joined us in September 2023 and is just a brilliant person to have around with the knowledge that's in her head. So Alex deals with a lot of high net worth individuals, and she also deals with owner managed businesses and high growth businesses. So very brilliant person to be able to have at our disposal and for clients to be able to speak to. So I'm now going to pass over to Alex, who will speak to you just before we pass on to the panel discussion.
Thanks, Rachel. Hello, everyone, and thanks for joining today, and thanks for the wonderful introduction by Rachel. So as she mentioned, I think the main headline changes affecting private clients are changes to inheritance tax, capital gains tax, and I think residency, so abolition of the non-dom rules, which my colleagues will discuss more in detail shortly. But I just wanted to briefly mention a few more sort of changes which may affect some of you depending on your personal circumstances. So for example, the stamp duty land tax. So those looking to purchase second homes will have to pay a higher amount of stamp duty land tax, with the surcharge rising from the rate of 3% to 5%. And unfortunately, there's not much can be done at this point, because this change actually has come into effect since 31st of October 2024. So just to be clear, the surcharge applies to acquisitions by companies of residential properties, as well as those individuals acquiring additional residential properties. So even if you're a corporate vehicle, we have to think about the relevant tax increase. And additionally, the 15% flat rate of stamp duty land tax applicable to companies, including non-natural persons purchasing residential properties valued over £100,000, will increase to 17%. So it means they could be as high as 19% for those non-UK tax resident companies, which is a bit surprising. But let's remember that these are all subject to those reliefs available for those in property investment, development, and or trading. And probably not as many now, but those holding UK residential properties in a corporate vehicle and are paying ATAD, the annual tax on envelope dwellings, will also see an increase in the ATAD annual charge by 1.7% in line with the September 2024 Consumer Price Index. And this will be applicable from 1st of April 2025. And then in terms of the employer NIC, I would say the rise in employers NIC, the national insurance contributions, and the lowering the threshold for this to apply was, I would say, one of the big headlines in terms of tax increases. So with effect from 6th of April 2025, the employers' national insurance contributions are to be increased from 13.8% to 15%. And the threshold above which they're paid is to be reduced to £5,000 from £9,100. And obviously, because with the increase in the minimum wage, this could add significant cost to those the business owners. And those with the children in private schools, I'm sure, like myself, as will see that there will be additional 20% VAT imposed on school fees from January 2025. And I have been asked by a number of people whether a parent's employer, i.e. a company they work for or they own, can pay for their children's education and hence try to recover the input tax that they pay on school fees. I just like to clarify that I think some webinars, they said it could be done. Actually, it won't be done. The companies will not be able to recover VAT. And also the HMRC has confirmed that they will review all those schemes in place, including fees in advance schemes for any potential tax avoidance and evasions. So I'll be very careful structuring that when we're having further discussions, if any of you is interested. Moving on to something less negative, I was quite happy to see that there was no changes made or introduced to corporation tax rates, full expensing relief, and annual investment allowance. And also no changes were made to those venture capital schemes such as EIS, Enterprise Investment Scheme, and SEIS, Seed Enterprise Investment Scheme, meaning that relevant income tax relief and capital gains tax relief for those schemes continue to be available. And also for those threshold in income tax and employee national insurance contributions will not change until the 2028-2029 tax year. Of course, there are more changes, for example, changes to tax regime dealing with the LLP, how the carried interest is going to be taxed for those with the investment funds business, and also the those running furnished holiday letting tax regime, it's going to be abolished. But if you'd like to discuss any specific tax concerns and issues, please do get in touch. There's an email, taxteam@bwv.co.uk, and we can have more tailored and more specific discussions. Now back to Dan and our panelists.
Thanks, Rachel. Thanks, Alex. That's all really useful. And it's really great to have Alex along, because it does demonstrate that there is so much that's changed in this budget, much more than we're going to be discussing today. And even more than that, and the message really is that VWV obviously specialize in most areas, and if there's anything you are concerned about relating to your business or employment law or anything in particular, you know, and we don't cover it today, do just drop us a line anyway, and we will find someone to help you and to give you that advice. And just from the top of my head, I'm thinking about potential changes to employee rights that will be brought in going forward. You know, we have an excellent employment law team that will be able to help anyone that's running a business that's struggling to decipher those. So yeah, thanks very much, Rachel and Alex, for that high-level overview. You'll see that the slides have been switched off now, so you get to see us slightly bigger. I don't know if that's a good thing or a bad thing. But we're now going to have a bit of a panel session where I'll be putting some questions to various members of the panel. We'll have a discussion, come up with some answers, some solutions, and see where we get to. Before we start with that, we do have a quick poll, which I'll be grateful if any of you could complete, if you have the ability to do that on your phone or however you're watching on your computer. You'll see it's just a quick question. It says, following the budget last Wednesday, which of these answers describes why you have joined us today for this session? So number one, that you're looking for a general overview of what's been put in place, or what might be put in place. Number two, you've got concerns about a specific aspect of the budget that's relevant to you and that you're a bit concerned about it. And number three, you're here in a professional capacity looking for legal insights. Obviously, we as lawyers have been attending lots of sessions over the last week run by accountants and financial advisors, and I think we're all kind of borrowing from each other to try and decipher what's been going on and come up with the best answers. So if you could answer whichever one of those answers is most relevant to you, that I'll be really grateful. Tamar, I don't know if we'll be publishing the results of that poll, or is that something we'll discuss later? Oh, there we go, as if by magic. So where are we? 52% of people here are just looking for a general overview. 13% have concerns about a specific aspect of the budget. So that's, you know, screams to me that maybe there's something there that's slightly more urgent. And obviously, you know, do drop us a line after today if you've got something you do want to discuss. And there's a fair few of you here in a professional capacity looking for an input from a legal perspective, which is really good as well. So thank you very much for that. Now on to our panel discussion. First of all, I was going to put a question to Angharad Lynn, who's our kind of resident expert in international matters and clients with cross-border issues. Angharad, the changes to the domicile regime, we've been talking about them for an awful long time because they were announced earlier in the year. Have the changes that have been announced, have they been in line with what was previously announced? And can you summarize what those changes are?
Yeah, more or less. I mean, it was the March budget that the previous government first mentioned these proposed changes to the domicile regime. And actually, it was quite interesting that Rachel Reeves didn't actually spend very much time talking about domicile in the actual budget speech. I suspect that may be because a lot of the detail was already known. It may also be because actually it's perhaps not the most interesting topic for people for whom it doesn't affect. It is quite a narrow part of the population who it does affect. But obviously for those who it will have an impact on, it's quite a dramatic impact. So the current system is that if you are non-domiciled in the UK, if you are not somebody who has what we call a UK domicile of origin, and you come and live in the UK, perhaps because you've been sent here with work, you can stay for up to 15 of the last 20 tax years before you become what is known as deemed domiciled for all tax purposes. So you can elect at the moment to be taxed on what's known as the remittance basis, which means that you can avoid paying tax on any foreign income and gains. And if you die within the first 15 years of residence here, of tax residents here, then you will then your worldwide estate won't be subject to UK inheritance. Your worldwide estate won't be subject to UK inheritance tax. Your UK assets will always be subject to UK inheritance tax, because UK assets are always subject to UK inheritance tax. But everything outside of the UK won't be. So that's been a massive advantage for people who come to the UK from abroad. The previous government decided to start looking at changing this regime, and they announced some initial rules back in March. And they said that from April 2025, we will have what is known as a foreign income and gains regime. The concept of domicile as we know it is going to be abolished. And basically, if you arrive in the UK and you haven't lived in the UK for the 10 tax years before that, you will have 4 years after you arrive, 4 tax years, when you will not pay tax on your foreign income and your foreign gains. And unlike the previous regime, you can actually remit those to the UK and there won't be tax to pay. The interesting thing about it is that it actually is helpful for British people coming back to the UK, as well as for people from overseas coming to the UK for the first time. So if you are British and you've lived abroad for a long time, perhaps you've been working in the Middle East or the Far East or somewhere in Europe, you return to the UK, you are also able to benefit from this foreign income and gains, or the FIG regime as it's being abbreviated to. So that might be quite useful for British people coming back. There will also be a window of opportunity, which they're calling the temporary repatriation facility, whereby individuals can remit to the UK foreign income and gains that arose in earlier periods. So they can bring that money into the UK, and the rate of tax will be lower than it would normally be. So it'll be 12% for 25 and 26, and the 26-27 tax years, and then rising to 15% for 27-28. So that will allow people to bring assets into the UK. The other thing that's interesting is the inheritance tax situation. As I mentioned before, if you have been living in the UK for 15 out of the last 20 tax years, at that point you then become deemed domiciled at the moment, and your entire estate will be subject to UK inheritance tax. The new system is that if you have been in the UK it was suggested that you were going to have to pay UK inheritance tax after you'd been in the UK for 10 years. But actually, and then after that, if you leave, it would take 10 years for you to lose that tail, if you like. But actually, that's now been clarified. So if you've been here for 20 years and then you leave, it will take 10 years to lose that tail. But if you've been here for less time than that, so between 10 and 19 years, it won't take as long. So if you've been here for 13 years, you've only got to leave for 3 years to lose that inheritance tax tail. So that might be quite helpful, both for foreign nationals who come and live here for a while and then go back to their country of origin, but also might be quite useful for British people who decide that they want to retire abroad, because they will be able to lose their exposure to UK inheritance tax after a certain period of being abroad. And until now, if you're British and you've got a UK domicile of origin, it's been quite hard to lose that. It's a very sticky thing, domicile. So that might make it easier for people from the UK who are retiring abroad, if they retire quite some time before they die. The other thing is that with trusts, it's traditionally been the case that if you are living in the UK but you're not domiciled here, before you became deemed domiciled, it was suggested that it was good planning to put assets into an offshore trust. And the rules about that are going to change, so that the advantages from a foreign income and gains point of view are not going to be there in the way that they were from April next year. However, interesting note in the detail is that there are some transitional provisions for assets that were held in trust that were established before the 30th of October 2024, and foreign property held in such trusts will be exempt from inheritance tax on the death of the settlor. So that is quite useful for people who have set these trusts up in the past, that they won't have to pay inheritance tax on the assets in them when they die, although they will still be subject to what's known as the relevant property regime, which means that they will be subject to 10-year taxation, but still quite an advantage.
I think, I mean, I've even before the budget last week, I've had maybe, I think I can think of 3 or 4 clients, high net worth clients, who have been talking about leaving. And they're usually clients that have significant assets abroad, not just clients with, say, a holiday home, but those with maybe the majority of their estate abroad have been talking about leaving. And do you think clients, do you think that will be a trend? How do you think clients might react to this? And have you noticed anything clients are talking about?
It depends very much on the individual circumstances, I think. I mean, you know, the truth is, for most people, where you live is not just about the tax regime, it is about your life. You know, people buy houses, they send their children to school, they make friends, they settle down. But then there are some people who have, you know, such wealth and perhaps also so many international connections that they feel equally at home in a number of different jurisdictions. So I think it will be a mixture. You know, some of the jurisdictions that are looking most attractive are places like Italy and Switzerland, and there will certainly be some non-domiciled individuals who decide that actually they don't want to stay here, and they think that the regime in those countries will be better. I would imagine there will also be some people who decide to move to places like Dubai. But on the other hand, you know, there will be people who say, actually, I've made my life here, my children are at school here, I'm actually quite happy. If I've got to pay a bit more tax, I will swallow that. So I think it will be a mix, but I'm sure, you know, I suspect there will certainly be some people who leave, and certainly talking to clients, there have certainly been some who've decided that they will be voting with their feet and they will leave before April 25.
But I guess a lot of that, you know, if you've got a life here and deciding to leave, and a lot of it's irreversible, and, you know, who knows what might change in the future. So we need to warn people not to do anything that's too irreversible, I guess.
Exactly.
We see clients, again, we see clients who are very much based here and have maybe a holiday home abroad. We also see clients that are non-dom and have, as we said, a large portion of their estate abroad. What type of client in your mind is the person who really needs to be looking at getting some advice now at an early stage? Is it everyone with any foreign assets?
I think it's mainly people who have been non-domiciled, who are suddenly going to find themselves domiciled here and who weren't necessarily expecting that to happen. So if you have been here for, you know, 5 years and you thought you had another 10 years before you would be deemed domiciled, it's probably a good idea to have a look at your worldwide estate. If you are deciding to leave, you may need to update your will, for example, because if somebody has been assuming that they are going to be here for the long term and now they're not, you know, the provisions of that will may need to change, and we may need to liaise with your lawyers in another jurisdiction. For people with a holiday home abroad who are not planning to move to live in that holiday home abroad, there probably isn't so much to do at the moment. But as I've said, if they are deciding to move to retire abroad eventually, there could be advantages, and that might be something to look at when it comes to doing some planning.
And I guess it's not all about the tax, is it? Ignoring the tax issues for a second, anyone with foreign assets, the people we see all the time, the people that you deal with all the time, they really need to think about their wills and how they've set up those. So it's not just all thinking about the tax and what you're going to pay on death. You need to think about now getting yourself sorted out.
Exactly. I mean, it's really important to take cross-border advice when you have cross-border estates. If you've got assets in more than one jurisdiction, it's really important to make sure that you've thought about how your assets will devolve when you die and which law will apply. Certainly if you've got a holiday home in a European Union country, you know, you can think about whether you want English law to apply if you're British national, or whether you want the law of that country to apply. And you can think about things like, you know, what sort of you know, structures are going to set up. For example, you know, assets falling into trust in the European Union are not usually a good idea and can be taxed quite onerously. So there's quite a lot to consider. And what we normally do in those sorts of cases is we will have a discussion with the lawyer in that jurisdiction where the property is located, so that we make sure that we cover everything and that, you know, we deal with the estate in a holistic way.
And Howard, I was going to sort of ask, it's probably a linked sort of question to that, but so clients who are thinking, well, that's me, I'm somebody who needs to review this now and to lift the bonnet on it all, but I haven't looked at this for a while. It can be quite confusing to know who to go to, whether you go to a lawyer, you go to a tax advisor, you go to an accountant, you go to a financial advisor. What would you say to clients who are sort of thinking, or potential clients who are thinking, who do I go to kick this off, and how do I join everyone up here?
Yeah, well, we're always really happy to work together, you know, alongside somebody's accountant and the financial advisor. I mean, the great thing about this firm is we've got Alex in the tax team now as well, so we can work alongside them. And yeah, Alex and I are meeting a client next week, aren't we, Alex? I think, who is deciding what he wants to do with his estate, and often working in conjunction with somebody who's got those other parts, you know, that other expertise is very helpful.
Yeah, and also just to add that we also have the US tax capability as well, so we can definitely look at cross-border element when it comes to that, because a lot of our clients do have access to the US and the UK. So I think we can probably sort of help you, even if you don't have an accountant in the UK. We've got a lot of like an extensive network, so we can always sort of bring all the relevant advisors together to help to navigate.
Probably also worth mentioning at this point that we do have a really strong immigration team as well, that not all firms have, and they do advise lots of wealthy families who have made that decision to kind of move here, on some of the more practical aspects of immigration as well. And that's, again, really good to bring them in from an early stage alongside private client lawyers to make sure everything is being looked at in turn.
I think that's
Sorry,
yeah, I was only going to say that I think that's helpful for people to know, because I think sometimes knowing where to begin can be the most difficult bit, knowing who to go to first. But I think if you can find a firm that has got expertise across the board and can coordinate and act as the sort of conductor of the orchestra, if you like, you can then begin with a lawyer. And yeah, I think that's really helpful for people to know. Thank you.
Thanks for that, Angharad. That was really detailed and really helpful. Just moving on to one of the other big things that was announced. Inheritance tax always seems to be something that's mentioned at every budget, and usually not much happens. It's usually grabs the headlines, but there aren't many changes, and it's been hasn't really been tinkered with significantly for many years. Seems to have come up quite a lot in this budget, and seems to be interwoven into a lot of the announcements that were made. Judith, I wonder, could you summarize, we've already talked in Rachel's presentation about some of the changes, but could you summarize in a bit more detail some of the changes that are going to affect inheritance tax?
Yes, thank you, Dan, certainly. Yes, quite a few changes announced. What isn't very helpful is that a lot of them are going to be subject to consultation come January. So in a way, the devil will be in the detail on a lot of these. So we've only just got some sort of broad headlines, which may well change later on. I think one of the main changes that will affect a lot of people will be the changes announced to pensions. Until now, your pension pot, your unused pension pot, was really free of inheritance tax when it passed on to the next generation. And in addition to saving for your retirement, it was seen as a very good investment pot, if you like, as a way to pass on money free of inheritance tax. Possibly because of that, the rules are now changing, or the announcement is that the rules are going to be changing, so that your unused pension pot and death benefits are going to be brought into the calculation of your estate for inheritance tax purposes. So there's going to be inheritance tax charged on them potentially. This is going to be brought in from the 6th of April 2027. So a bit of a way to go now. And as I say, there's going to be a consultation. The other point that I've read is that it isn't as though the pension pot will come into your estate and be available for paying the tax, distributions, whatever. The pension providers, the pension administrators, are going to be responsible for reporting the death to HMRC and dealing with payment of inheritance tax. So you're not even going to get the whole pot. You'll get it net of inheritance tax at some point. Who knows how long that might take to get through. So it's all part of the uncertainty, really. I think the other point on this is that a lot of people will have structured their affairs so that they can take advantage of the residence nil rate band, which most people will probably be aware of. This is an extra allowance of 175,000 per person, tax-free. Sorry, the lights go out if I sit still for too long. It's an extra allowance of £175,000 free of inheritance tax if an estate includes a property which is going to pass to the next generation, to direct descendants. However, if your estate is worth £2 million or more, then you lose the residence nil rate band. So it's possible you might have structured your affairs with your house, which is worth less than 2 million, and your pension pot might be another million, but it's going to be free of inheritance tax. It's passing not any longer if these rules go through as announced. So your £1 million pension pot's going to be added to the value of your house and the rest of your estate, and you're going to lose that extra residence nil rate band as well, because you're over the £2 million limit. So there's various sort of quirks, really, and maybe unintended consequences, I don't know, but it's certainly something that's going to need to be looked at carefully. And I think as well, I mean, you see in the papers there's potentially a rush for people to take out their tax-free lump sum and make lifetime gifts of that, but it really needs to be looked at in the round, I think, and some specialist pension tax advice on what's the best thing to do.
And phrases like BPR, APR, so business property relief, agricultural property relief, they're often, when we have meetings with clients, I find they're often phrases that many clients aren't even aware of. Even if they own a business, they're not aware of business property relief because they've been so busy building their business up and running it that they haven't really thought about succession. I mean, that's been all plastered all over the papers. What are the main changes in that area?
Well, the main changes are until now, agricultural APR, agricultural property relief, BPR, business property relief, have meant that you can pass on your farm, pass on your business free of inheritance tax. That is now changing, and there's going to be a cap on the amount that you pass free of inheritance tax. And that cap is £1 million. So if your business is worth more than that, or your farm's worth more than that, then potentially there is going to be a charge to inheritance tax. It's sort of trumpeted as being a charge at a rate of 20% rather than the usual 40%. But actually, it's the way it's been expressed that above £1 million, half of it is still free of inheritance tax, and the rest is charged at 40%. So the headline rate is 20%, margin rate is 20%. But it is going to make a big difference, because if there's going to be a tax charge, what's going to happen to your business? What's going to happen to your farm? And as Rachel said, there's lots of lobbying going on, or will be going on. The NFU is going to get militant, and who knows what the upshot will be. But certainly there seems to be quite a lot of confusion as to how many farms this is going to affect. So I don't know where the truth lies on how many farms might be affected, and likewise small businesses. But if you're going to have to meet an unexpected tax bill, will there have to be sales of a business? Will you wind it up? Will you be selling off farmland? Is what's left of the farm still viable? All those questions as well.
And Judith, there is, of course, currently the option to be able to pay inheritance tax by instalments against particular assets. So I've seen a little bit of commentary saying, oh, well, don't forget, it doesn't all have to be paid up front. Even if this is the case, we can be paid in up to 10 annual instalments. But as we previously talked about, those instalments are currently subject to a healthy rate of interest.
Absolutely. And every time you see that mentioned, interest doesn't get mentioned. And so whether there's going to be some concession on that or whatever, is this part of the consultation? Who knows? But yes, and that interest rate at whatever it is now, 7%, really ratchets up quickly. The other thing I've seen on this as well is that oh, well, yes, it might be £1 million, but if you've got a husband and wife who own the farm jointly or the business jointly, then each of them has £1 million allowance. So if a wife dies first, she can give her share of the business to the next generation, and there's £1 million allowance to set against that. And then husband dies second, he's got £1 million free, tax-free as well to pass on, but he will also have the benefit of 2 tax-free nil rate bands that everyone has, plus the residence nil rate band. So that's another £1 million there on its own. So all of a sudden, yay, 3 million is going free of inheritance tax. But that's too simplistic, because it's not allowing for, as I mentioned before, once you get more than 2 million, you lose your residence nil rate band. And it's assuming that it kind of works on the ground, literally on the ground, to be passing part of the farm on to other members of the family who might not want to be involved in farming, just because you've got to do something with this asset. So I don't know. I mean, there's going to be lots of consultation. It's not going to end here, but yeah, it's a major change.
It sounds like we might be, we'll have to wait for the detail, but we might be going back to the sort of pre-2007 position where people would have to use their normal nil rate band or lose it. And then thankfully they changed that in 2007, but now we look like we're getting a sort of Groundhog Day version of that with the with BPR now.
Yeah. Exactly.
Another phrase or term which I think clients are usually unaware of is AIM, or the AIM market. And there's been some BPR changes for shares on the AIM market as well, isn't there? Can you just explain a bit about what the AIM market is?
Yes, the AIM market, AIM stands for Alternative Investment Market, and these tend to be smaller companies. Years ago, when the AIM market first came into being, they were viewed as very risky investments. And you were really, well, not necessarily throwing your money away, but they were certainly not the place to put your money for safety. They've now become more mainstream, I think, and most investment managers would be able to set up an AIM share portfolio for you. And although they are smaller companies, the big benefit is that once you'd owned them for 2 years, they were free of inheritance tax. So they'd be part of your estate, but not subject to inheritance tax. And that was a great thing. That's all changing now. And they will be subject to inheritance tax at a rate of 50%. Sorry, 50% relief, rather. 50% is tax-free, with effect from April 2026. So that is a big change, and it seems a bit odd if these are smaller companies that you're investing in and the government wants to encourage business and investment, but now you're going to be penalised for having done that. So yeah, AIM shares is quite a big change. So you're only going to get inheritance tax relief on half of your asset.
And the some of these kind of vehicles that are set up to hold AIM shares, the value of these funds has been really affected by this announcement, hasn't it? Because all of a sudden, one of the main reasons you would buy these shares is gone, or nearly gone. So again, a lot of people are up in arms about that, how this has affected those valuations.
Yeah, exactly.
Of those things that you've sort of highlighted, just trying to get your personal opinion really, and what do you think? I mean, it sounds like maybe the one you mentioned first, pensions. Is that what you think is going to have the biggest impact, or are you not prepared to nail your flag to the mast yet?
I think that will be the biggest one, yes, because far more people will have pension pots that they've built up over some years. People are encouraged to save for retirement, and now the pension pot is going to be brought into the inheritance tax net. More people are going to have a pension pot than will have a farm or a business or possibly an AIM share portfolio. So I think it's the pension changes that will be the biggest.
And is there anything, this is kind of a difficult question but is there anything that maybe should have been changed, or in your personal opinion, you think they could have tinkered with that they haven't done, for us to think about maybe for future budgets where they might look to change some inheritance tax stuff?
Well, I suppose the residence nil rate band, this extra tax-free lump, which applies if you're passing, and state includes a property which is passing to the next generation. I mean, that could have been abolished, I think, because it's horrendously complicated. I mean, as a number and a concept, it's easy enough, but when you get down into dealing with it, it is horrendously complicated. And it's also, I think, a slightly unfair tax in that if you don't have children, you don't have direct descendants, you don't get it at all. So it's, I know we are family oriented, but nevertheless, it seems a bit unfair. So that could have been abolished, I think, and maybe the quid pro quo could have been to increase the basic nil rate band, which is 325,000, and has been, or by the time we get to 2030, it will have been unchanged for 20 plus years. And I think I read somewhere that if it had just been increased by the retail price index, it would be nearly double what it is now. So I think that frozen for an extra 2 years till 2030 is unfortunate.
Thanks for that, Judith. I mean, I think this is probably the area where we're going to get most queries, to be honest, because there's quite a few juicy changes in there. Inheritance tax has always been one of the more unpopular taxes. So if people can try to get their heads around what their own liability might be and get some advice on how they can protect against that, I think that's probably what people are going to be looking to do.
And Judith, if a client was to ring you and say, how do I know if I'm somebody who needs to review my own personal legal affairs in the light of this? How do I know if I need to check my will, dig it out, look at this trust that I set up and whether that still works, whether it's still helpful or not? I'm sort of testing you now, but what would you say to that client who rings up and asks you?
Well, I think the important thing will be to sit in the comfort of your home and gather together all the information that you can as to what assets you've got, where they are, if you set up trusts, when you did it, what sort of trusts they are, if you made lifetime gifts, when you did it. In other words, get the overall picture of what your estate is likely to comprise, and then come and see us, and we can look at we can go through it and make some suggestions for how you might restructure things, or make gifts, or set up trusts. As I say, the difficult thing is this consultation period, so we don't know what's going to be the result of that. But I think if you think you might be affected by these changes, then I think it's a case of getting all your ducks in a row, having a look at what you've got, having a look at what your will says, and then come and see us, and we can take it from there.
And I don't know if you agree, Judith or Layla or anyone on the panel, but it sounds to me like the gifting regime, the seven-year gifting regime is still going to be quite a powerful tool, and something that maybe more so than ever clients should really be looking at what they can afford to gift away. And this is really, again, something where you need to bring in a financial advisor, so you can try to work out what can you afford to give away? What can you afford to give away to your children or to a trust or something of that nature? And that's another thing, isn't it? That
Yes.
gifts to trusts don't seem to have been tackled at all in the budget. And that's, again, another sort of door that's been left ajar.
Yeah, I think also, if I may add just one more thing, I think it's not also just about the person giving it, because you've got to think about the person who's receiving it. And the fact that now a lot of people live or work in different countries, you know, like, for example, I don't know, my children might study abroad and end up living in a different country. So you've got to think about all that as well. So recently I had to advise somebody who's based in the Far East. The person is British national, but living in that country for 30 years. Now he's caught within that local inheritance tax regime. So you've got to then look at, so what are the tax position? Could we get any credit for taxes paid in both jurisdictions? Is there any double tax rate in place? Unfortunately, the tax conventions that covers inheritance tax, there aren't that many countries with the UK. So you've got to sort of think about that as well, you know, as, you know, you're planning all your personal, you know, gifting or the inheritance affairs in order.
And Alex, we were talking, I think it was yesterday, about the importance of also reviewing family investment companies and how they still seem to be a viable option for high net worth clients, maybe an alternative to gifting or the trust route.
Yes, as everybody mentioned, sort of including inheritance, I think it really comes down to your sort of objective, right? So there's no one size fits all. You've got to think about what you're thinking about, what kind of asset, types of asset, and whether the corporate vehicle is better than trust vehicle or the partnership vehicle. So you've got to think about that. And I think, of course, it's quite technical, as Judith correctly mentioned. I think it's better for you to sort of look at all your affairs and what kind of assets you've got, what you want to do, what you want to give away to whom. For example, whether it could be your children or someone else, or you might donate it to charities. I mean, you might have different ideas what you want to do with your assets. So once you have sort of a bit of an idea, then, you know, come and talk to us. I think then we can sort of see, you know, what's the best way that we can make that happen.
So if we've got clients who are kind of hell bent on the trust route, it's quite really good to have you there, Alex, that we can just, you know, grab you and pull you into a room to talk about some of the other options available as well.
Yeah.
Great, thanks for that, Judith. As I said, I think that will be where we get a lot of our questions and queries. Just a quick reminder, if you do have any questions that have sprung up with the format of how we're doing this today, you have to put them in the Q&A box, which you should find at the bottom of your screen. So do type your questions in there, and we will try our best to deal with them if we get some time at the end. But we're doing okay for time at the moment. But if you have got any questions you want to raise to the panel, please do pop them in the Q&A box at the bottom. Amish, you've been sitting there patiently and quietly waiting to join in. I was going to ask you a bit about the last aspect, which is capital gains tax. It was one of the areas where there was a lot of talk before the budget, a lot of predictions that would be something that they would look to change. What, if you can remember back to pre-budget, what were the things that people were talking about changing, and what has actually been announced in comparison to that?
Yeah, absolutely, Dan. So there's been, as you said, lots and lots of speculation in the lead up to not only this budget, but budgets before in connection with capital gains tax. Most of the speculation was not whether capital gains tax would go up or not, but how much it would go up by and what assets it would apply to. In addition, there was also speculation as to if capital gains tax did go up, when would it be enforced by? Would it be an overnight thing? Would it be on the day of the budget, or would it be the next tax year? So the Chancellor has clearly lived up to the expectations and has gone and put capital gains tax up, but it's not as severe as some people had thought. There was talk about capital gains tax potentially being aligned with income tax, which would have meant, in the worst case, some people having to pay 45% capital gains tax. So whilst the changes aren't as severe as they could have been, clearly they do still have an impact, because where someone would have been a basic taxpayer and paying capital gains tax at 10%, they're now having to pay at 20%. And equally, if they were paying as a higher taxpayer at 18%, they're now having to pay at 24%. The capital gains tax on the sale of sort of buy-to-lets and second homes, that hasn't changed though. So that was 18% for a basic taxpayer and 24% for a higher taxpayer, and that stayed as is. So if anything, they've aligned all of capital gains tax together, or certainly those parts. So it means that potentially calculations are slightly easier. And it's the changes are in force as of budget day. So if you made a sale on the morning of budget day, sold some shares, for example, and that made a capital gain, that would be subject to the new higher capital gains tax amounts at 18 or 24%.
And what about the obviously the CGT allowance? They've been whittling away at that for many years in many budgets. Where do we stand at the moment on the CGT allowance?
So the CGT allowance didn't change in the budget. So a few years ago, it was 12,000. Last year, it was halved to 6,000. And this tax year, it's been halved again. So the allowance isn't, it's meaningful, but not massively meaningful. So there's only so much you can do in terms of kind of, if you've got an asset with a big gain, and some people might sort of salami slice it and say, well, I'll do 10% this year, 10% next year. It simply takes too long to kind of fully plan your estate when you're dealing with it that way. There are some other options, but it's kind of specific to circumstances where potentially capital gains tax could be held over. So the person that you're giving the asset to, it has to be in some sort of vehicle, but they might take the base value that you acquired the asset at. So there is still potential for planning, but the allowances are much smaller than they used to be, which makes our lives a bit more difficult, but also for clients looking to plan, you have to look at other things you can do and other things to consider.
So for a client that has a excuse me, a rental property where they've owned it for many years and their acquisition value was very low and it's now very high value, they might just be thinking, oh well, I'm not going to sell that because I'm not willing to pay the capital gains tax charge. You're saying it's worth having a discussion because there might be some other options.
Absolutely, yeah. So so capital gains tax is, I guess, as you put it, in a way you sort of volunteer to pay it because you make the choice as to when to dispose of a certain asset. So if you've got a buy-to-let or a second home or something like that, you might say, well, I want to give that on. So if you are, worst case, a higher taxpayer and you disposed of it, you'd be paying capital gains tax on your gain at a maximum of 24%. So some people might find it difficult to fund, which is an issue because if you're giving something away, you're not getting anything in exchange, and therefore you might not have the cash to physically fund the tax bill. However, if you do have the cash to fund it, you might say, well, do you know what? Let me give it away now. I'll pay the tax bill. I'll hopefully survive 7 years. And that's better. It's better to pay 24% on the gain as opposed to 40% on the whole thing in your estate. So there's definitely planning that people can consider to look at and potentially mitigate their tax bills. But it has to be done holistically. We need to look at kind of speak with financial advisors, make sure the person gifting has enough assets for themselves to make sure they can live a comfortable life. So it's a big picture sort of thing, and you sort of want to look at it as a family unit to make sure that what you're doing, yes, it might be good for mitigating tax, but does it actually work as a family, or whoever you're gifting it to if it's non-family?
And Amish, the same sort of question that I put to Judith really, but just in the context of CGT planning now. So for an individual wanting to sort of kick off a review and maybe hasn't engaged on this for a while, would that be going to a lawyer first? Would that be going to your financial advisor first? I mean, at some point, everybody's going to have to join together, but who would you go to first to start these conversations?
Well, I might be a bit biased, I guess, as a lawyer, but I'd go to my lawyer.
Yes, it was a trick question, Amish.
But often people speak to their financial advisors about it. We, so as a team, we often get a lot of people coming in to say, well, I haven't updated my will in a while. And as part of those discussions, we usually look at all of their assets just to make sure the will bites and does what they want to those assets. And then there's a wider discussion of sort of allied planning, tax planning. And at that point, we will say, well, this is some potential options. What do you think? But before we actually implement anything, we'd get a financial advisor in to say, actually, can they afford to give that away? Because if they go into care, that sort of thing, will they need the money? Or if they need to fund a certain type of lifestyle, will they be able to continue to live the way they want to live? So it's definitely multiple people involved. Often, I would say it starts with lawyers, but sometimes financial advisors as well, but both are usually involved.
Thanks, Amish. And I know I've got some questions coming in. I know we're waiting at the end till the end for the majority of them. There's one here that is relevant just to your little section here. So perhaps for Amish and Judith, it says, will these CGT changes apply to lifetime trusts?
Yes. So they will apply, and for those you normally pay at the higher amount anyway, so it will be the 24%. So if there's a portfolio of stocks or shares and you're making a chargeable gain, those CGT, that new 24% CGT will apply.
Thank you.
We've talked a lot about individuals who maybe have assets that are pregnant with a lot of capital gain. And you mentioned a little bit about estates and people who are currently maybe acting as executors or trustees in an estate administration. What, from my point of view, I feel like when we're dealing with estate administration, that's where a lot of stuff can happen where CGT is involved. That it's not voluntary, so it's not something you can, it's an asset you have to sell maybe, so you can distribute to beneficiaries. What are some of the things people need to look out for if they're dealing with an estate administration on behalf of somebody who's passed away, from a CGT point of view, Amish?
Yeah, absolutely. So whilst you're living, as we said, it's kind of a tax you volunteer to pay disposing of an asset. An executor might not have the same choice. He or she might need to dispose of an asset, one, to settle a tax bill, two, because the beneficiaries don't want the asset, but they want to be paid in cash. But for example, an executor, when someone passes away, the capital gains value is uplifted to the date of death value. So if the value goes up after the date of death, that's when an executor needs to look out for potential capital gains tax bills on disposal or sale of assets. The executor might not have much choice, so they just need to factor that in. So to give you an example, there might be someone might have passed away. They have a house worth $500,000. By the time the estate's kind of administered and things are going and they've found a buyer for the house, the market might have moved and the house might now be worth $550,000. Not an uncommon situation at all, even within a matter of 8-9 months. So what the executors will then need to think about is, well, who's benefiting out of this? Can we give them the house instead and they can dispose of it and use their own personal allowance? Because the executor's allowance is half of that of a beneficiary's in an individual capacity. The other thing the executors might want to think about is, well, no, we can't give the house away because we've got a large tax bill to pay. So if we give the house away, we're going to be left with nothing, and HMRC is going to come after us as executors. So it's a careful line. You want to maximize the tax benefit, but equally you want to make sure that the executor's not left holding a tax liability without any assets to pay it with. The other common examples of when capital gains tax might become payable, and it's not something you tend to volunteer for, but unexpected tax bills personally. So some people have to sell kind of stocks or shares if they've had a large income tax bill, but they've kind of used the income. People might want to sell AIM shares given the changes, and they might have gone up in value. So then they'll have capital gains tax to factor in there. And also about selling businesses. So the capital gains tax on businesses is changing as of 2026. So you as of now, any businesses that are sold subject to certain conditions being met, you pay 10%. That is going to be changed. So you're going to have be paying at 14% and then 18% in the next couple of tax years. And finally, one to look out for is when people sometimes go into care and they need the care to be funded. So they might be selling a home that's been let out. They might be selling stocks and shares just to fund the gap between potential pension income or other income and care fees. And care fees are, I mean, they're extortionate. So there is usually an element of disposing of capital to help meet those costs.
It certainly sounds like CGT is one of the more, one of the riskier things to plan for when we're dealing with an estate or personally, and quite, these are normal situations that people can find themselves in, as you said, having to fund care, and then suddenly being hit by a tax bill. It seems a little bit unfair, but it's something that clients have to plan for, isn't it? And I think, if I'm right in saying that when the payment of capital gains tax, you've got a pretty strict deadline to get that paid. Is that right?
Absolutely, yeah. So if it's a second home, something like that, a buy-to-let, you've got a 60-day deadline to pay it in, file and pay. If it's kind of sale of stocks and shares or kind of other assets, and then you're looking at filing it with your normal self-assessment, so you've got a bit more time. But certainly the deadlines are one to watch out for, and they sometimes can be missed if you don't tend to file kind of a self-assessment and you've disposed of something and you've sort of forgotten about it because it was last year, and you might forget, and you might fall foul and kind of get some penalties.
Yeah, no, thanks for that. Sorry, it seemed like a bit of an exam question. We were just firing questions there, but you came out of it very well.
I'm glad to hear.
Great, so thanks for that, and yeah, thanks to all the panel actually for your really detailed answers. I'm hoping that has sort of created a lot of thought in people's heads, and I can see we have got some questions. Layla, do you want to run through any of those?
Shall I do a few now, Dan?
Yeah, I think so.
Yeah, I will sort of put them out to the panel, although it might be that kind of those whose areas these falls into want to answer them. So a question here about, are we aware that whether there were any changes to trust anniversary or exit charges?
Shall I take that one, Judith?
By all means. I'm not aware of any.
No, I wasn't, but I thought I'd check with you two experts.
No, me neither. There's no changes that were announced to the sort of 10-year charges or exit charges. However, the only one to look out for is with the changes to APR and BPR, which are normally exempt. When you come up, if you're holding that sort of asset, when you come up to your 10-year charge or there's an exit charge, that will, subject to consultation, potentially be taxable now.
Yeah, one thing that's quite interesting though is that in the detail, it suggested that if trusts were set up before the 30th of October, that each trust, so if somebody had set up multiple trusts before the 30th of October 2024, each of those trusts will have £1 million allowance for APR and BPR. Whereas if you are setting up trusts in the future, an individual setting up a trust can only set up, well, they can set up as many trusts as they want, but that £1 million allowance will be divided between all of their trusts.
Yeah.
So that's an advantage for people who set up their trusts earlier.
If I could just sort of slam us into reverse slightly, Amish, I think it'd be really handy just for the people listening. Could you just give a quick overview of what the anniversary charge is, because some people might not be aware. Sorry, you're on mute, Amish.
There we go. That's a bit better. So it's essentially when you've given away assets and settled out assets outside of your estate that you can't benefit out of usually, but they're not held in anyone's estate. So if someone was to pass away, they wouldn't be in their estate. So instead, what the government did was said, well, instead of, because we're not getting the 40% that way, instead we're going to look at the value of these assets each 10 years that aren't held in anyone's estate, and we're essentially going to put a tax charge on that. After the allowances, the tax charge works out each 10 years at about 6%. So over the course of about 70 or 80 years, it works out to 40%, which is what the government might have got or similar. So that's how they worked it out initially. It's a bit complicated and a bit burdensome, but it is beneficial for estate planning at times. So people do set these things up, and it's a safe way of sort of passing wealth, but safeguarding it potentially against divorce or kind of financial difficulties for anyone that you wish to benefit. And then the exit charge is similar. So if say you're looking at a 10-year charge and the tax charge is £2,000, if there was an exit of those funds to someone's estate, someone individually, anywhere between sort of 0 and 10 years, that exit charge would be linked to the 10-year charge. So if it was halfway, essentially it would be a half the 10-year charge.
Thank you. And
depending
it's
on the assets leaving.
It's something clients need to plan quite carefully for, isn't it? Because if a client decides they want to settle a property into trust, they need to be aware that there is going to be that 10-year anniversary charge payable. So if there isn't any cash available at that 10-year period, they might they might have put themselves into some difficulty, or they might have to make another addition to the trust to actually fund the tax bill.
Absolutely, yeah, and the addition in itself might become taxable as well. So where clients have done this, especially with farmland or businesses as well, subject to the consultation and the changes coming in where the exemptions aren't going to apply, funding might become an issue. So careful planning is needed to make sure that the tax liability can be met.
Thanks, Amish. I think it's really good to spend a little bit of time on that point, because there's a few questions in here that are along the lines of, do we think, or do we anticipate more and more people gifting into lifetime trusts to try and now reduce the value of their estates?
Yeah, I think the only thing is to remember to remind everybody that once you make a gift into trust, if you gift more than £325,000 into trust, there is an immediate charge to inheritance tax at 20%. So if you put, say, for example, £500,000 into trust, the 175,000 above the 325 will be taxed at 20% immediately. So, it's quite a lot of money to find up front if you're looking at those larger sums. Obviously, a married couple could do 650,000. So for some people that will be the right thing to do, but it doesn't come without certain costs, and also reporting obligations. That trust will need to be registered with the government's trust register, and you will need to complete tax returns, and there'll be these 10-year anniversary charges and exit charges. So it's not without administrative burdens.
I think there's just to jump in, Layla, I know it's sorry, your questions, but I can see a really good one, which to be honest, I'm not really sure of the answer, but it's, will I need to change my will to mention pensions?
Well, I was just about to say that, Dan. Yes, I was just about to say that. You beat me to it. I was going to say, Judith, that is a really good question, because I think so the question is, as Dan says, do I need to change my will to mention my pension if it's now going to be taken into account for IHT? And it's a good question because it draws out, I think, the difference between how your pension passes on your death versus how it is taxed or will be taxed. Judith, I'm going to pass this to you.
And I don't know the definitive answer on that. I mean, it's going to be the reason I don't know is because the pension administrators are going to be responsible. It's going to go out again in a minute, aren't they? The pension administrators are going to be responsible for reporting to HMRC on the death and dealing with payment of the inheritance tax. So what's coming back into your estate is
a good question, because
are they still going to deal with the rest of the pension pot as you've nominated it?
Yes.
Or is
One would imagine that they probably
going to come into your estate?
But presumably this will be part of the
consultation, but one would imagine if you've made a nomination form, because most
Yeah.
people who've got a
Yeah.
SIP will prepare a nomination form leaving the SIP to their children, for example. One
So
would
it will be-
imagine that will continue.
Yeah.
I would imagine the same, but it's a very good point, and it will be interesting to see it thrashed out, because yes, there are a number of people who leave different nominated beneficiaries for a pension pot to the beneficiaries that they might set out under their will for various different reasons. So
Absolutely.
yes, it will be interesting to see whether that net sum will come back to the estate and pass under the terms of the will, or as Angharad has said, and as I also would anticipate, it continues to pass out in accordance with your nominated beneficiary form. But that's a very good question.
Yes.
Dan, am I carrying on with questions, or are we doing, have
No,
we got
got-
enough
got
poll?
time
Am I
for-
making
got
that up?
time- No, got time for another question, I think.
This is, I suppose, are we surprised that there was no change to the 325,000 personal nil rate band allowance?
A
I think
bit.
Judith kind of already answered that one, and that it's been frozen for so long, and it's really interesting, Judith, when you mentioned what it would be if you counted normal inflation, it would be almost double, which is quite shocking, actually.
Yeah.
I think we all probably agree that doing away with the residence nil rate band and then bumping up the normal nil rate band has got to be the way to go. But someone in the government has probably done some sums and worked out that that's going to result in a loss of tax, so they've
Well, I
decided not to do
suspect that
that.
is the problem, because I mean the truth is that, as Judith said, it's a very unfair allowance in that it only benefits those who've got children and who own property, or who have owned property. So and it's very, very fiddly to deal with. So it would make a lot of sense just to increase the nil rate band, but clearly there's no appetite for that at the moment, and presumably it's for reasons of they've done the sums and it's cheaper to keep it the way it is, or more, it raises more revenue to do it the way it is at the moment.
I think, Dan, I've probably just got one more on here that might be a good one to ask. So we've talked about gifting in the context of potentially gifting into lifetime trusts, gifting that way, but in terms of more sort of or lesser gifting, so gifts out of surplus income perhaps, or using annual gifting allowance, are we aware? I think the answer is no, but I'm going to check with you all whether there's been any changes to those gifting allowances.
I don't think so.
I don't
Not
think
aware
so.
of anything. There was a lot of thoughts in the press, social media, etc., before the budget that there might be some sort of wealth tax imposed, or that the 7-year survivorship period might be extended, or there'd be something like that. But none of that seems to have materialized.
And also those small allowances, the sort of £3,000 that you can give away annually, or the £250 to as many people as you want. I mean, those haven't changed for years and years and years.
No.
So, in some ways they are ripe for change, but clearly there's no appetite, again, presumably because, they would raise less tax.
But they're often overlooked by clients, aren't they? Because they are relatively small, and a lot of the clients we deal with are high net worth. But if you think about the cumulative effect of a married couple, say, using their annual allowance every year, making sure they do it, £6,000 a year between a couple. If they do that for 30 years, the cumulative effect of those gifts is going to be huge. And it's not just the value of those gifts they would have got out of their estate, it's what that money would have grown to over that 30-year period as well. So it could be a significant sum.
I think that's right, Dan. I think often that it's the attraction is the sort of big, quick wins, but actually long-term and cumulative can be just as valuable in terms of planning. I think they are, given the time, they're perhaps the questions that are sort of most relevant in terms of us being able to talk about it as a panel at this point. Thank you to everybody who's added a question. It's really great to see so much engagement and kind of sparked us being able to talk about this in a bit more detail. So thank you.
Sorry, as I was probably getting ideas above my station and answering questions. I'm supposed to be just chairing and letting you guys answer, but it's an interesting topic for all of us. No, thank you very much to everyone for all your input, and thank you for everyone for the questions. Tamar, I think we've got a closing slide with our contact details on. So if and also a final poll. So if you could, whilst that page is up and you furiously jot down email addresses and telephone numbers, it's all available online as well if you want to find us. So just Google search VWV and whichever name you're looking for, and you'll get those contact details very easily. But if you could just answer this final poll, which is just about how you found today's session and how your views might have changed. But what best describes your position now, having listened to us or having listened to some of the other budget talks that you've been to? So will you be looking to speak to a lawyer ASAP? So that may apply to clients who maybe haven't updated their will for a while, or haven't got one, or need to talk about lasting powers of attorney or trusts or anything like that. Number two, you're going to take some time to think about things. Again, might not be a bad answer, given that everything's in consultation and we don't quite know the answers to how this is all going to pan out. Or the third, that you think you might see a pensions advisor or a financial advisor first, and then maybe link in with a lawyer afterwards. So if you could answer that poll, that would be really handy. Thank you. And again, I'm hoping that as if by magic, some answers will pop up. There we go. So most people are taking the conservative approach, and they're going to have a think about things. And again, that is not a bad approach. Scoop up as much information as you can. Stay in touch with us. We will obviously be releasing things. We have a newsletter called News and Views, which goes out periodically. I think it's every quarter, if I'm right, to our clients. So do sign up for that if you want to, and you'll get that through the post, and it will be full of stuff about the budget for many, many months, I'm sure. And yeah, so just keep in touch. Send us an email if you've got any queries immediately, and look out for further updates. I'm sure once the detail and information starts to come out regarding the budget announcements and the consultations, more importantly, we'll be running some more sessions.
Yeah, and Dan, I think we're going to email a sort of budget version of Viewpoint out over the next week or so as well, so people can look out for that too.
Great. And do go to our if you do go to our website to look for any contact details, do go to the events section, and you'll see in there we do run a series of webinars, free webinars throughout the year, which are run as workshops. So they're a little bit different to this session in that everyone's faces will be visible on screen, and people are sort of encouraged to join in the discussion and ask questions directly rather than through the chat box. So do look out for those as well. But other than that, unless anyone else has got anything to add, I think we can probably close there.